Hearing, hearing. The Court of Appeal for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on before.
Welcome to the virtual version of the First Court of Appeals. I'm relieved to note there are no cats on the screen today. We have one case set for submission. Case number 01-20-00395-CV, Darling Homes of Texas, LLC versus Wade H. Curry et al. Can I get the appearances of counsel for the appellant?
For the appellant, Bob Plosala, representing Darling Homes.
And for the appellee?
For the appellees, Matt Parmet.
And Mr. Plosala, you are reserving 5 minutes for rebuttal?
That's correct.
All right. You may proceed as soon as Mr. Parmet is removed. There he goes.
All right. May it please the court. My name is Bob Plosala, from the firm of Andrews Myers, and I represent the appellant Darling Homes. I want to start by addressing where we find ourselves at the moment procedurally. As you know, as the movement seeking arbitration, I have the burden to prove that there is a valid contract containing a valid arbitration clause that encompasses the claims being made in the lawsuit. Having done that, and if I do that, then it's up to the other side to prove a defense to arbitration. Where we are right now is the validity of the contract below was not questioned, that the claims fell within the contract was not questioned. I have briefed on appeal that we proved and met our burden, our initial burden, and the other side has not opposed that or briefed it whatsoever. So where we are right now is I've met my burden. What's left is whether or not below Curry and the remaining appellees met their burden to prove a defense to arbitration. And it's our position here that they did not. The first point is, let me divide up their claims. First, they argue procedural unconscionability and substantive unconscionability. Procedurally, they claim that the contracts themselves, rather than the arbitration agreement, was induced by fraud. They made that argument below. They have not briefed that up here. They did claim below and have briefed up here that the arbitration agreements are not sufficiently clear. They presented no evidence that any of the 150 homeowners was fooled, missed something, didn't understand what they were signing. And as you all know, the law in Texas presumes that when somebody reads a contract, they're presumed to have read it and understood it. The agreements themselves are very clear.
If it is ambiguous, don't we make that decision as a matter of law?
I think they have to raise that below, your Justice Kelly. They have to raise that argument that it's ambiguous. What they said, it wasn't sufficiently clear, and they presented no evidence of that.
Do they have to show reliance on that ambiguity, or that the ambiguity actually caused them to inadvertently enter into the contract?
I believe they do. I think the starting point first is, are they ambiguous? And these agreements can't be more clear. Any and all claims arising under the contracts are subject to or will be arbitrated. I'm paraphrasing, but there's nothing in them that's ambiguous. But if they are going to claim that they're ambiguous, they need to claim they're ambiguous below and make that argument and present some evidence. What they said was it's not sufficiently clear. They didn't say it was ambiguous. They said it wasn't clear, that they were waiving their right to a jury trial. And as we pointed out in our briefing, an arbitration agreement is in and of itself a waiver of jury trial, and that's what Texas law holds. That's the Wells Fargo case, and I believe Massey versus Galvan out of the 14th Court. So if they don't present evidence that something's not clear, then they haven't met their burden to establish procedural unconscionability. What's left then is substantive unconscionability, and they've made several arguments, three of which they did not make below. But when it gets right down to it, they claim the rules that the parties agreed to, the construction industry rules, are unfair, and the arbitrators that would be appointed under those rules will be biased against homeowners. Let me address that first. There's no evidence of that. They've attached the rules, but they haven't demonstrated how they're unfair, and they have not presented any evidence, expert or otherwise, in affidavit form that says the arbitrators who are appointed under construction industry rules are going to be inherently biased against homeowners and biased in favor of contractors. There's no evidence of that. But
Can I ask you a question, Mr. Plosala? what sort of discovery was conducted prior to the motion for?
I apologize. There was no discovery done. No, there was a discussion during the first hearing in November of 2000. The time's blurring. I think it was 2019, where there was discussion about whether any was necessary. The judge at the conclusion of the hearing asked Appellee's counsel point blank, what you're talking about is, counsel, merits discovery rather than arbitration discovery. She didn't answer the question, but he said, you didn't answer my question. But what she was after, what they were discussing was merits-based discovery from Darling Homes. The discovery that would be necessary, or where the evidence would come from if they were going to present evidence, would be from the appellees themselves. They would be having to present affidavits that they were fooled, they were fraudulently induced, they didn't understand, those types of things. Or, for instance, when it comes to the substantive unconscionability argument concerning the cost, not one of the appellees put on evidence of their financial condition. Nobody proved up what the fees would be or what the cost would be, especially in light of the ability for hardship waivers under the AAA rules. They did not prove up the burden that it would put on them, what their claim was in comparison to what the fee would be. That evidence is totally lacking. But if they needed discovery, they could have done that. Well, they really don't need discovery because they can just do an affidavit about their own financial condition. So discovery was not requested.
Well, Stella, can I ask a question? Is it established anywhere whether these claims would be arbitrated separately as opposed to en masse? And does that make any difference to cost determination?
I think from the standpoint of whether these claims have to be arbitrated, I don't think that factors into things. The contract's silent on that. However, it's just like in any other proceeding, that the issues about whether they're going to be consolidated, whether they're going to be trialed separately, whether they're going to be filed together, are going to be decisions to be made by the arbitrator or arbitrators, the AAA itself and how it administers arbitrations, and obviously the parties themselves. The parties in arbitrations involving multiple parties frequently agree to do things like consolidate for discovery or consolidate all the claims. But that's the next hurdle over after we get past arbitration. I hope I answered your question, Justice Hightower.
Yes.
Okay. Again, the main thing on cost, you have to have some evidence of it. All the cases are fairly clear that if you just, not fairly clear, they're very clear. If you just attach AAA rules or fee schedules, as a matter of law, that is insufficient evidence, legally insufficient evidence. That and there are examples of how you do it. For instance, the Ayala versus Olshan case out of the San Antonio court, I believe. That was by the foundation. The plaintiffs proved up that their claim was only $22,000. The fee was going to be $35,000, and they got a bill from the AAA to prove that. It was like 48% of the husband's gross annual income and 28% of their combined income. The court held that that was an unconscionable fee under the circumstances of that case. We have no idea what the position of the appellees here is because they didn't prove anything. They presented no evidence as the Supreme Court requires. They simply argued or speculated about what it could be. And as a matter of law, in the Supreme Court cases, Olshan Foundation for one, that's insufficient as a matter of law. So having failed to do that, I come back to where I started. The main problem they have with their defenses is, under the Royston Razor case, it's clear they are required to prove their defense. And they did nothing to prove their defense. They offered speculation and argument about what might happen, what could happen, but not what they claim is happening with evidence. And so having failed to do that, then I return to what I believe my discussion in the brief was the standard review. Once, I believe it's the first merit case. Once the trial court concludes that arbitration agreement encompasses the claims, the party opposing the claims has failed to prove its defenses, the trial court has no discretion but to compel arbitration and stay its proceedings. And we believe that as a matter of law, that was what happened here and what should be done.
Mr. Plasala, say we agree with you, and we send it back, would the homeowners get another shot, another bite at the apple of submitting evidence?
I don't think so. I mean, they've had their shot. I mean, the only thing that's left to do now is, based upon the record they presented, is the court, a judgment should be rendered that the trial court stay the proceedings and compel arbitration. Because they don't, I mean, we don't get two shots.
How would they get evidence of how expensive it would be?
For purposes of what, your Justice?
Well, for instance, they want to show that it's substantively unconscionable because the costs outweigh the, it's too expensive to do. Now, the only information that's publicly available might be the AAA arbitrator fees. But how do they know other things, the cost of other things, the entire proceeding, for instance? How can they prove that?
Well, through expert testimony, for one. I believe there was a case, one of the cases, if I'm not mistaken, it's the Poly America case, where the plaintiffs there obtained an expert testimony from an experienced arbitrator who engaged in arbitrations under the rules at issue. He opined about what the cost would be and what the fees would be, because keep in mind, as the appellees point out, there's not only a filing fee, there's also the fees to pay the arbitrator for his time. But that you can do that through expert testimony. You can make inquiry to the AAA. But that's only one part of it. The other part of it is what is the impact of the fee on them? And I think that's a very critical point that is wholly lacking here. And I see my time's up for now, unless somebody has one of you had another question. I'll pass.
Any other questions? Thank you, Mr. Posala. And now for Mr. Parmet.
Good afternoon, Justices. Matt Parmet on behalf of appellees. May it please the court. The focus, a lot of the focus is, as Mr. Posala just addressed in the briefing, was certainly on some of the procedural issues. However, as we've addressed in our briefing, what we think is more important for the court to consider are certainly not to disregard the procedural aspects, but regarding the substantive unconscionability. And one thing that wasn't touched on yet, I believe, but we're actually dealing with two different types of arbitration provisions in these two separate types of contracts. The first one, which everyone's taken to call the Type 2 agreement, contains a provision which allows the seller, not the party initiating, not the party defending, but it actually specifies that the seller chooses on an appeal. On an appeal whether or not the FAA or the Texas Arbitration Act applies. And I'm sorry, that's not just the appeal, but because it doesn't specify. Presumably the whole arbitration is then governed, and we don't know what law applies, and the seller then chooses that. There's no time restriction. There's no other restriction on this. As a matter of law, that's illusory. Quite simply.
Why is that illusory? How does that affect your substantive rights? I mean, if arbitration is really just a change of forum and not a change of substantive law, what substantive rights would the plaintiffs be losing if, let's say, midstream, Darling Homes switches from FAA to TAA?
Right. So we addressed a couple examples. I'll talk about some of those. One of the examples, it really applies most pointedly in the appeal. And so you can see how this plays out in a couple different ways, which is the standards are different in terms of what, for example, what the standard for an impartial arbitrator is. It may be slightly different, but it's different. And so what could happen perceivably in one of these arbitrations is that you get all the way through, you realize an issue's come up with your arbitrator, and on appeal, Darling Homes decides, you know what, we're not going to apply the FAA's stricter standards. The Texas Arbitration Act is actually a little bit different, because if there's a non-disclosure, it applies harsher on the non-disclosing arbitrator than the FAA. And so you can see a situation where Darling goes, well, if it went well for Darling, well, no, we think the Federal Arbitration Act should apply, not the Texas Arbitration Act. And so the case law is pretty clear on this. And
does that really meet the standard for an illusory contract?
I believe it does, Your Honor, because the issue really becomes that this party is free to change the rules at any given point in this whole entire litigation or appeal process. And the cases are pretty clear on that. There's a lot of, as Darling pointed out, there's a bunch of employment cases on that very issue. that we had pointed out. And there's not really a difference in the employment context. That's just where we happen to see it a lot, where the employer tries to do the same thing. They try to reserve the right to claim what rules are going to apply and try to do it down the road. And one thing I want to touch on
that sort of touches on another point about economic disparity of the actors, that we respective actors we have here. What evidence was introduced to the trial court relating to the homeowner's ability to pay for arbitration?
Yes.
Is there expert testimony? Is there statements of net worth? Are there, expert estimates of what the proceedings are going to cost?
There weren't, Your Honor, in this case. What we saw was pointing to the AAA rules as well as the filing fees in this case. Now, what Mr. Plosala addressed and what the court's heard before is that, there wasn't attached affidavits, there wasn't expert testimony. But the difference between this case and other cases is we know in this case what the rules would be. So what you saw in Olsham versus Ayala was, well, the parties are going to decide on an arbitrator, and there isn't a set AAA. What the cases have said, specifically, actually, in another Olshan case, which was just In re Olshan, but in that case, the Texas Supreme Court said you don't have to prove with certainty what the costs are going to be. You just have to prove.
Right, you don't have to prove with certainty to the exact penny, but right. You do have to have some proof. Honestly, I probably believe that I probably support the proposition that arbitration is one of the biggest scams foisted on the American public by the legal profession. But that's not the question before me right now. The question we have is, have the homeowners complied with the strictures set out by the Texas Supreme Court? And we look at the quantum of proof that was required in Poly America and the quantum of proof that was accepted to be enough in Olshan. What have you done to reach that quantum?
So let me draw a slight distinction between and make sure we're on the same page, because there's a difference between, I think, the discovery issue and the proof issue with regard to the arbitration costs. Because there was some discussion below about, and y'all, we've discussed this afternoon a good fair amount about the actual state of discovery at the time that the decision was given. Now, we can look back in the record and see that discovery did not end up being a dispositive issue for the court in terms of needing more of it, because it was decided looking at the arbitration agreements and the documents on file. So I think I just want to make sure we're separating that from the issue of what can we look at to see what the cost would be. And here we can look at the AAA's filing fees, because those are a matter of public record. They don't change according to what a specific person we're going to, we don't change. They're not an escalating or a changing cost. They are set by the AAA. They're available publicly, the same way that the court's filing fees are. So we know what those are. Yeah, yes.
Do we know whether there's one arbitration fee or 81 arbitration fees?
I heard that question before. That is not an issue that was firmly addressed below. We operated under the assumption, and so this is for the purposes of this appeal in the lower briefing, that there are 81 different arbitrations that are going to be had here. And because there's nothing consolidating them. There's some case law, especially recently, regarding arbitration presumptively being individual. So in all likelihood, we're talking about 81, but I don't believe that's been a settled issue, if that's a fair way to put it.
If I can ask a question, is there anything in the record that would give us any indication of your client's ability or inability to pay arbitration fees?
I don't believe that anything addressed that specifically. The main issue that we talked about with regard to the cost was the fact that, and this is an issue with the type 1 agreement, which is in that one, the construction industry rules apply as opposed to the homeowners rules. Now, the AAA had a rule change at some point in the early, I don't remember the year offhand, but in the mid 2000s maybe, that specifically took homeowners from being a subset of rules into being their own set of rules. And so what we see actually in the type one agreement specifically was that the construction industry rules apply as opposed to the homeowners rules. And those rules, for example, required something like a $7,000 filing fee to get things started off. They also differ in terms of the procedure because of the way that the panel is selected, and the panel constitution, which we talked about, as well as the cost. Now, what Darling has said on appeal in response to that is, well, that's only if we don't agree otherwise. The problem with that argument is, which they've made about a couple things, it's like, oh, well, we can agree otherwise. But the problem is that the default under these rules is actually, if there's no agreement, we just go to the thing that's the most onerous and the most unconscionable as to all of these homeowners, not to default the other way around.
What happens to your argument if they agree right now to follow the homeowners rules and not the construction industry rules?
Well, I mean, I don't think they've done that. So there's other issues out there that require agreement, not just that one, but they haven't done that. So, the issue, I guess, is, we're not talking about a default coming to something that's the fairest or the most equitable for anybody, or the least onerous for the homeowners. The default on all of these issues is, which is a contract that obviously that Darling drafted, is that it goes against the homeowners on each one of these issues, whether we talk about the FAA and the TAA, like we were talking about before, or regarding these industrial rules and the way that
what's in the record to support that the construction industry rules are unfair? Is it just the document for us to read, or is there any testimony that those are an unfair methodology?
Yeah, that was, besides the appeal, obviously that was brought up in some of the briefing, including in the supplemental record. That one I don't believe, and we've talked a little bit about that. I think that's a matter of law for the court, and an issue of law and not of evidence. In my experience dealing with arbitration, I think that one would qualify as well as something that can be decided as a matter of looking at the contracts and looking at the law.
And those rules are in front of us?
They are. I believe it's the appeal. The appellate record starts at 1133 for the industry rules, and at 1087 for the home rules. The other issue, which I just wanted to touch on, one other thing about the which I first started with about the FAA and the AAA, and this, which applies to some of these other, mostly to that issue, but that we don't have to have completely divergent standards between the FAA and the TAA to make something to raise that issue on appeal of whether or not something is fair or in the seller's discretion. And let me explain what I mean. There seems to be, and to address Justice Kelly's question from earlier, look, there's a slight difference between the TAA and the FAA, but they're mostly the same, which is kind of what Darling has argued a little bit. Is, yeah, there may be some differences. The problem is you only need one difference on one issue that the seller can raise, and we're not even going to know that till after we go all the way through this arbitration, all the way through that hearing, and see what either Darling or the homeowner is going to appeal on, for them to then decide, oh, you know what? And one issue, we're just using an example, one difference in the statutes themselves is that the TAA under section 171.008, section 4, allows the defense of no agreement to arbitrate with an objection raised at the hearing, which does not appear in the statute in the FAA. And the issue of waiver comes up as we see.
To what extent might the FAA preempt the TAA in this circumstance?
So the issues of preemption, which was not fully at issue to discuss. So I apologize. I don't know offhand exactly how it would play out, but there's only the general FAA preemption is only applying where there is, I believe, some overlap and on this issue where you allow them, you expressly allow them to choose which one applies, I don't know that a preemption argument would work either way because they're allowed to make that choice afterwards. So because the express language of the agreement that Darling drafted allows them to make that choice, I'm not sure that you could argue.
If the FAA, I mean, so you're saying that there's a conflict or there's a major distinction, some substantive distinction between the FAA and the TAA, but the FAA preempts in the case there's a conflict. So why wouldn't the FAA always apply when there's a significant conflict?
I believe that generally the FAA would preempt when you have a first of all, when you don't have the specified statute under which you're applying, or second of all, which we see sometimes in these cases where there is no arbitrator that's appointed. So for example, I think this will maybe address your question. A lot of the preemption cases focus on, look, they just said arbitration. We don't know whether it's FAA. We don't know whether it's TAA. They just said to arbitrate. And so the court can come in and make that decision based on the law that's based on the law that's at issue in the lawsuit, based on the dispute, and based on whether or not there could be an issue with exemption. Here, that's not what happened. They actually expressly reserved their right to claim which law applies, which I think is probably a little bit different under the calculus of these courts, because you generally don't see this. If the court's filling in a gap or resolving an ambiguity, it does it across the board to everybody. Y'all meant to say the TAA. Y'all meant to say the FAA. But here,
there might be some that the plaintiffs would have some estoppel argument that if Darling Homes decides to change horses and switch from the TAA to the FAA or vice versa, they could say, no, wait a minute, you're stopped from doing that because we have proceeded, you made an earlier representation that the TAA applies and not the FAA, and we proceeded under those rules, and that would prevent a switch. And I think a court acting reasonably, on whether to affirm an arbitration award, and there was such a switch, would probably find that they're stopped from switching midstream like that.
I don't disagree with you at all, Justice Kelly. I think the only place where I draw a distinction here is that there's no requirement that they select that governing law at all at any time. So there's no requirement that we have to say going into arbitration, okay, Darling, what's it going to be? There's no requirement that they do that at any point ever. And so conceivably, you could have that for the first time on appeal.
Let me ask one kind of follow-up question along there. I'll agree that the language in the type 2 where it's talking about the TAA versus the FAA gets a little ambiguous and was a little hard to follow. But I know in the briefing from the appellant, their argument, as I understood it, was it seems to clarify, if you read the entire provision, that the FAA would apply. Do you recall that from their briefing and have a response to that?
Yes, I'm very familiar with what you're speaking about, Justice Hightower. I disagree with them because the issue, if you read that whole provision in context, and we talked about this as well, actually in section. I was just looking at it in a section later on in our brief as well. The issue is that it's very, again, admittedly very poorly drafted, and it indicates that, well, maybe it applies to just these defects. Now, first of all, there could be a defect at issue in this case, which there is an issue. There's a defect issue in this case, so it doesn't really matter whether it's just that section or the other sections. However, the reference language with regard to the appeal, with regard to the FAA versus the FAA is specifically about the appeal. And that language is not anywhere else in the arbitration agreement. So there's other things that indicate, look, it's going to be the FAA. Here's the FAA, that shows up a few times. But the only place we see anything about an appeal, which talks specifically about a mandamus or an appeal, is that section that we reference with regard to FAA versus AAA. And so again, this is an ambiguity, and that should be construed against Darling, who had drafted this.
Thank you.
Any further questions from the panel? Thank you, Mr. Parment.
Thank you.
Thanks.
I think I'm back.
You're back.
I'm back. Let me address that topic briefly. The type 2 agreement starts out that any and all claims will be arbitrated, and it ends with pursuant to the Federal Arbitration Act. The business about the Texas Act has to do with an interlocutory appeal from the denial of a motion to compel arbitration, which we are doing right now. Nothing in that clause refers to any final appeal. It's strictly this. And that's because when this contract was drafted, that's what the law used to be. Until 2009, there was no interlocutory appeal when a Federal Arbitration Act motion was denied. You used to have to do mandamus. It's just old language. But the clear the clear text of this statute, the contract, pages 1198 to 99 of the second volume of the record, says any and all claims will be arbitrated at the end pursuant to the Federal Arbitration Act. And it's the same with the type 1 agreement. And I wanted to get to a question that Justice Kelly raised about whether or not we would agree to any other rules other than what's in there. The fact of the matter is, I agree with you, arbitration is a scam. And frankly, the beauty of the way that the type 1 agreement is written is the parties can get together and agree to do whatever they want to do. They don't have to file with the AAA. We do ad hoc arbitrations all the time. You agree upon applying a set of rules, you agree upon the appointment of an arbitrator, and you don't pay any fees other than to the arbitrator. That's highly preferable than worrying about which set of AAA rules apply. But at this point, while I'm standing here, I can't say one way or the other whether or not we would agree to use the homeowner rules. I'm just saying that all that is a fallback, and all the parties have to do is sit down and agree on the rules, and they can make it as cheap as they want to be. As far as choosing the AAA over the Federal Arbitration Act in general, and we disagree that we have that election, other than that one subpart, and that's for an interlocutory appeal when a motion to compel is denied. But the remedies on a final appeal from on a rendition of an award really have no bearing on whether or not arbitration is required. The rules themselves are interchangeable, as the Supreme Court has noted. The one conflict I'm aware of is there is some rules that say that the parts of the Texas Arbitration Act don't apply to small fee cases, like under $50,000 at stake. That's where the FAA would come in and say, we got that covered. But there is no conflict. As far as the homeowner versus the construction rules themselves, there's not much to it that's different. That basically those rules apply. Yes, one's in homeowners, but they apply. That many of the rules are almost interchangeable, and there was no inherent harm shown by either one of them as would impact a homeowner. And I think it's also important to point out at this stage that the most glaring problem we have here is the total absence of proof of their defenses. They admit, or at least tacitly admit, that we met our burden. They did not meet theirs. What they did was they just put on a schedule of the fees, and the Supreme Court says that's not good enough. It's not, as a matter of law, evidence to defeat a claim. And I have basically gotten to the point where I think I've said all I can say without repeating myself. So unless the panel has any other questions, I will give back the rest of my time.
I did want to ask you the same question I asked Mr. Parmet, which is, can we infer whether there would be 1 or 81 arbitrations, or is that subject to agreement?
I think it can be subject to agreement. It can be subject to what the arbitrators want to do and the AAA. Frankly, I wouldn't just haul off and file 81 arbitrations without sitting around and talking with the other side about it. There are many instances where, for instance, it may work out that the fee structure of 81 arbitrations is cheaper than 1 arbitration, but nobody's looked at that. I think that would behoove the appellees to look and see whether that's the case, because it may be it's more efficient to file 1 arbitration and maybe separate the final hearings. But I don't think that factors into whether or not the arbitrations to be undertaken. But I certainly do believe that if this thing is done, if we're arbitrating, we're going to have to sit down and talk about how we're structurally going to do it, 81 or 1. But I don't think either way is mandated. And with that, unless the panel has any other questions.
No further questions. Thank you very much, Mr.
Thank you.
Casala.
Thank you.
Darling Homes versus Curry is now submitted, and the First Court of Appeals is now adjourned. Thank you very much for your time, Counselor.
Thank you.
Thank you.